first cases. But
What kind of case is it? What if it's child?
it's
Oh.
because it's not family friendly.
How very much on the subject. Well, he's saying the Zoom link wasn't attached. Let me try that again. Okay. Oh, shouldn't say that. Sorry. Thought I was in my kitchen. Send the response now.
Okay, either one of you have a client with 470 number 486.
I believe that might be Miss Brew.
Oh,
Don't look at me. It only so much effect.
oh yeah, so much hurting of cats.
People are waiting, so I'm just waiting for her to come out. There's, you know.
I'm just.
final plea calendar. So I'll do a quick call here. Position 1, Rogers.
I am present on that, Your Honor. He indicated he was coming. He might be a little late. Mr. Rogers? Yeah, there he is.
Oh, okay. You, Mr. Rogers? Okay. Position 2, police.
Ms. Please, she is present, Your Honor. You have to stand up.
Position 3, Shepherd Tigner.
Present on that, Your Honor. Mr. Sheppertinger sent me an email indicating he's in the hospital currently, but I did send him a Zoom link and he is on.
Okay. Position 4, Sharp.
That she free for this case. She has to speak right now, but on Zoom, but gonna be doing.
Is Miss Rockwell? I mean, I see she's on, but is she on? A minute here.
She's actually asking for.
Hi, Judge. Judge,
Yes.
how you doing?
Good. How are you? So what's going on with Shaquanta Sharp?
Okay, so I filed a limited entry of appearance. Did she show up? Because I don't have a,
Are you Ms. Rockwell?
yes, sir.
Are you ready?
I'm not ready.
Yeah.
Not ready. We too far apart.
Okay.
Okay, thank you, sir. I'm sorry, Judge. I'm on leave and I'm in 2 courtrooms, one in person and one. Thank you for giving me the Zoom link. On Ms. Sharp, Judge, I want some direction from the court if I could get some. I filed a limited entry of appearance, stood up for her first appearance and her bond hearing. I think she got out of jail. I have not heard from her since. And if the court wants me to, I will file a motion to withdraw.
Yeah, let's look it up here.
So, waiting to touch her. Did she show up?
I don't think, I mean, is Shaquanta Sharp here? Let's look her up.
While y'all are looking her up, I have 2 people. Maceo Usher is on the line. Mr. Roderick Davis just called me for the Zoom link. I apologize. I haven't sent it to him yet. I'm about to send it to him so you can see his face. But I was requesting a reset because I am technically on leave. I filed my leave January the 3rd of 2023. Judge, this leave request.
Yeah.
Does
What
that
about-
work?
Well, I mean, I'm just trying to get first things first. I mean, what?
Yes, sir.
So you filed a limited entry of appearance here. We see it here. And so that was just to do the bond?
That was for her first appearance because the gentleman that hired me. Do you want all the gruesome details?
No,
He
I
paid-
really don't. No,
He-
no.
I mean, he paid me with a credit card, then he canceled look, all I know is she got
I'm
out.
not one, I actually, I am all for special entries if it means first appearance or having a bond hearing. So
Yes, sir.
I'm not, I do not take issue with that. I'm just trying to figure out the history here. So.
Yes, sir. So my request to the court is, are you directing me to, and I will file a motion to withdraw. But regarding her presence, I have no way to get in touch with her if she has not shown up. I would just ask Madam Litigation Manager if you can see whether or not there was a return to sender. Or if you can tell me who the bonding company is, I'll immediately contact them because most bonding companies make you give about 10 relatives with 10 phone numbers, email addresses, et cetera. I'll find her, Judge. If
What'd
you
you
can
say?
tell me who made a bond.
Jet bonding.
Okay, I can figure that out.
Can you reach
you
out
just-
to them? I mean, because
Yes,
I'll
sir.
give you a little bit of time before I do a bench warrant and bond forfeiture. All right.
Thank you so much on her.
Okay. All right.
Okay, and I also will file a motion to withdraw because it looks like my name did get on her.
Well, I
Name.
did see your limited entry of appearance, but I guess it would clean it up if you did file that withdrawal on there as well. Because
Okay, can the court tell me what kind of calendar she's on today?
this is
because-
final plea.
Well, I mean, I don't even know when she had her arraignment or her,
You filed it. Well, I have that in my notes. You filed a waiver of formal arraignment
okay,
and requested discovery. That's in my notes. And
okay,
that was May 4th.
okay. Then I'd need to file a withdrawal. But I don't even know if she was there on that day. I can't. As
I
an
expect
officer
she
of the
probably
court.
wasn't because you filed a waiver.
Well, she probably wasn't because, no, we haven't seen her since I saw her that
Well,
day.
I mean,
first
there's no
appearance,
point in
okay.
discussing any further. I mean, just
Right.
let me know by the end of the calendar if you hear from her. If not, we're going to do a
Okay.
bench warrant and bond forfeiture. I mean, it's time for her to
Okay.
remember that she's got, court and
Yeah.
aggravated assault charge out there. So,
Right, very serious charge. If you let me stand down just on her, I'm gonna get
All
in
right.
touch with Jet Bonding, try to get her, her information and get
Okay.
her. I do have two others on the calendar, Judge.
Okay. All right. Position 5, favors.
And Your Honor, I'd ask if we could retry that with the state.
All right. Position 6, Simpson.
I am present on that, Your Honor. He should be online. I just sent him the link this morning. But we have worked out a pretrial intervention agreement, Your Honor. I just need to get a little bit more information from my client, and then we'll give that to you to sign after the state looks at it and approves.
Okay.
That is correct, Judge.
All right. Position 7, Usher. Renee? We'll come back.
Good morning, Judge, again on him. He is on for a final plea, Judge. I have my request to the court, since I am on leave of absence, I was requesting another final plea on him, please.
Let's see here.
He should be on Zoom, Judge. He was in the waiting room.
I'm here.
All right, we'll reset this, but when we reset it, let's schedule a trial for it as well with that final plea. Okay, all right,
Thank you, Judge. May he be excused. I'm gonna stay on because I have one more that I
Yeah,
have not.
he's-
sent
he's
the Zoom link
excused.
to. Thank you, Judge.
well, here, you're up next with Roderick Davis.
Judge, I can tell you unless the state challenges me, I can tell you as an officer of the court, he just called me and asked me to send his Zoom link to a different number. I could send it to him so you can see his lovely face. That's going to be the same request, Judge, a final plea / trial calendar. We can keep everything open.
Now,
As
we
a final
reset
plea.
it back in March, for a final plea. And
We did, Judge, and and it was for October the 11th, but I'm sorry. I'm sorry for, it was for a different day, and I don't remember what day it was for. But anyway, that's my request, Judge. And do you need me to get him on the line? I promise you, I just talked to him. He called me while I was in open court in front of Judge Malone. That I had told everybody October the 2nd.
Titus, we had it down for the 8/31, but then that fell through.
That's just my request, Judge, since I did file my leave on January the 3rd, 2023. I requested leave for this period.
Let me come back to that once you've got your client on the line.
Yes, sir. I'll stand down and get him on the line. Thank you.
Position 9, Govia Vasquez.
Good morning, Judge. John Greco from Mr. Vasquez. For some reason, Judge, I've never actually received discovery by reaching out to the state several times. I'd like to pre-try today, but I don't have any information.
What's your last name again, sir?
Greco, Greco.
Okay.
And we filed discovery request along with the waiver back in, I believe it was.
Who's got this case? Is it you, Mr.?
Yeah, I'd be happy to talk to you.
Okay. All right, I'll take a break at some point, y'all. Position 10, Ricky Ivory Brown.
Mr. Brown is present, Your Honor. I'd ask if we could pre-try that.
Okay. Morning. And we're back to positions 11 and 12, Little and Ingram. I mean, I don't know if there's. I'm
Believe we're headed for a trial.
yes, I'm deep into thought on your 418 motion.
And actually, if I may reveal something for the record on that.
Sure.
Cert was granted this morning.
I saw that.
In the McKinney case, I was planning on following up in writing. I did alert opposing counsel on my way.
Yeah, I saw that, but it's probably not going to be heard till February.
Correct. That's for the argument.
That's a good point.
That's that big argument. Your Honor, I also have received notice for counsel for Ingram as well. He's had an emergency situation come up and I happen to approach, but that's why he is not.
Who you talking about it?
Counsel for the code, the code offender.
Oh, okay. That
I just would rather, if I may approach on that and if the court requires an explanation.
I don't know if I need one, so
Understood, Your Honor. And
I'll just take your word that it was an emergency and we were all in here yesterday, so
emergency.
Monday. Well, it all blends together. Yeah. Let me ask you, I mean, would it be appropriate for me to ask you something on a 418 motion right now? I was considering alternative means, but since you're both in here, as I'm deep into thought on it. Oh, well, yes, that would be a good idea.
So it doesn't.
Let's circle back around on that. And if you don't want to address it, then I'll email all parties or figure out some other way to ask my question. So.
You know, I'm here today if I need to be called back from defendants here. It doesn't affect.
I'll tell you what, let's go ahead and bring out Little. I don't think it does. I mean, it affects because it's a co-defendant, but Tucker really didn't speak to any of these issues. But if we feel it does, then we can move in a different direction.
And I'll alert him to the matter, and then if there's anything we need to take up later, it would probably more impact the severance.
Yeah, I didn't think it would happen, but a denial assert would have been a little more black and white as far as as far as things.
Sure, the court's aware who plans on arguing.
Pardon me?
I'm sure the court's aware who plans on arguing.
All right, just straightforward. It's fine. I'm sure it was an emergency. So I simply, and if the parties have an issue or another way, but regarding the 418 motion argument yesterday, this is something that inevitably occurs in your mind once you're digging into this. But you have the nexus regarding the current charge and the predicate act, and I think everybody agrees with that. And then there's debate, of course, over the previous charges that they or previous, it doesn't necessarily have to be a conviction, but the previous acts coming in. My question is regarding what is the dispute over if there's a dispute over Mr. Little's gang connection, because there really hasn't been any evidence offered. I know Ms. Jones brought that up a couple days ago. I mean, that's sort of the first door that you have to get through before you're discussing any of this. I mean, how would you propose handling that procedurally? Yes.
And there's one other matter on this motion that I'd like to address. The statute reads whether or not a person is charged with an offense under 1615-4.
And he is.
He is. Remember, the nexus language as proposed by the defense only applies to one of the subsections in the way they have articulated it under 1615-4. And he's charged with not only A, that would be the A violation. He's also charged with the B violation, which is attempting to increase or maintain status in a criminal street gang through the commission of offense. And he's also charged with E, if I'm remembering the indictment correctly, which is essentially, was he encouraging someone else's participation in the gang? That's essentially criminalized as part of the crime with gang charges. So the first matter is, their argument doesn't encompass the impact of the 418 evidence on the indictment itself, because it's an A-based argument, and we have other counts here that came up with McKinney. That specifically came up in McKinney. So now, does the state have to prove a 1615-4A violation pre-trial in order to allow 418 evidence to be admitted?
I mean, that's.
And the answer to that's no. The state has to have charged somebody with a subsection of 1615-4A, and it wouldn't 1615-4, and it wouldn't have to necessarily be 1615-4A. Somebody could be charged with merely an E violation.
Let me ask you this hypothetical, and maybe I don't. So let's say we go forward to trial, and this is a hypo that has zero to do with Mr. Little standing here right now. But let's say we go to trial, and I allow I grant the motion, I allow the prior acts in, and the state presents their testimony regarding whether the defendant is in a gang. And everybody in the room, jurors, everybody except maybe the state agrees it was awful. There was really no connection whatsoever to a gang. But yet now we've barfed out all these other acts. I mean, how do I unwind that, or how do I charge a jury? Do I say, well, it's up to you to determine if the defendant was in a gang or not, but if you don't think he was in a gang, then ignore all this other stuff because it's inappropriate for you to be considering it.
Well, if someone was charged with rape and other offenses, if 413 evidence came in, then there would not be an argument, well, they acquitted on rape, somehow that was improperly admitted because the defendant was committed of a burglary. So there are cases where the Supreme Court has dealt with the fact of whether or not gang evidence that was admitted pursuant to a gang act violation charge was erroneously introduced after a review of the case when the defendant was committed on the predicates and not the gang charge, which is essentially the court's question.
Yeah.
The Supreme Court has answered that, the Supreme Court, and I believe the case is Kemp v. State. Kemp v. State. That's a case out of Cobb County in the late 2010s. Primary consideration in Kemp is the expansion of co-conspirator hearsay in gang cases, but if I'm remembering my citations correctly, Your Honor, Kemp and a cluster of cases that came out in and around that time out of Cobb County stands for the proposition of that, merely because there's an acquittal of the gang charge doesn't mean the gang evidence was improperly admitted. And there are several statutes that kick in when 1615-4 is charged. There's 24-4418, the one we're dealing with here. There's 1653, which deals with gang customs. There's 1659, which deals with other acts of the gang. And then there's 1511-703, which deals with bringing in juvenile adjudications. And all of those only apply in a 1654 context the way they do. So Judge, we're dealing now with a 403 issue, which again, the man's charged with murdering a child as part of his gang activity arising from a domestic dispute. And of course, the proffered 418 evidence is very similar, at least in terms of the rise from domestic matters of, again, I know Ms. Besa put those up, but they arise. And again, given the severity of the charges here, the unfair prejudicial impact would be very, very low at their admission. I just wanted to make sure I addressed.
No, and I get that. And the 403 is in the mind, but like 413 and 414, it's all prejudicial, but the statute invites it. So it has to be, I forget the qualifier. Is it exceptionally or
the danger of unfair prejudice is substantial.
substantial? Thank you. Yeah. Yes, thank you. All right, Ms. Jones.
Thank you, Your Honor. I did not bring my file.
Well, I apologize for
Kinda
dumping
catching
this
me.
on you, but
Put it here a little bit, Your Honor. I haven't necessarily looked at Kemp v. State, but again, we would just stand on our argument that there has to be a nexus shown in regard to this. And the state didn't even proffer what specific gang they think that he is in. They didn't proffer that a detective is going to testify to X, Y, and Z to even establish that he was in a gang, which gets to the prejudicial element of it, that this is just going to be regurgitated to the jury. And if the
so you're
state-
arguing 403 right now.
Well, I think it's all together. I mean, there's two aspects of it. There's the nexus that we argued on Monday, that there has to be a nexus to the gang activity and furtherance, that this somehow was related to furthering his connections within the gang and his standing and all of that. We don't think, one, that was shown. And two, there is that second prong.
When you say the nexus, are you talking about the current case? Or are you talking about the previous cases, just to be clear?
There should be a nexus between the allegations of the previous cases to this case in regard to how it elevates his standing within the gang, how it furthers the gang.
And we did argue that
We
2
did.
days ago, but
And I would stand on that, but I think it also just goes to the prejudicial aspect of it too. If it was allowed and the state can't show any of that, well, the cat's out of the bag. Now the jury has heard all of this prejudicial information that the state couldn't support. And certainly they didn't proffer any of that Monday. And I think at least that would have been appropriate if they're going to want gang activity and how this is in furtherance. What gang?
Yeah.
Citation for Kemp versus State is 303 Georgia 385. It's a 2018 case. 303 Georgia 385. And again, that deals with the expansive reading of 801D2E. That's the co-conspirator exemption from the hearsay rule 24-8-801D2E. And interestingly, like this case, because the defendant's been indicted for being associated with the gangster disciples in this case, so it's clear what gangs involved, it's gangster disciple. There's been discovery indicating those matters and also connection to the Goodfellas gang, which we could get into how all of that works, but that's really not of moment here at this hearing. The question is,
No.
I'm charged with 1654, and I want to read from.
Well, it's a final plea, but it's just a,
But in terms of the elasticity of the co-conspirator exemption, let's take a look at page 394 to 395 of the Kemp decision. The fact that defendants were ultimately acquitted of the gang charge does not alter the analysis. So what we're talking about there is.
I know you said it has to be charged. It's not,
Right,
it's
right.
not, I know that's your contention,
And
but
so, and that dealt primarily, I think, with an analysis of 16-15-3, which is the subsection dealing with gang customs that was added in 2010, I believe. Again, we're making a sort of the defense is making a post-verdict argument about whether or not something was properly admitted, when now we're dealing with rules 103 and 104 and very permissive standards of admission and statutory,
well,
if not a clear command, but certainly encouragement for the admission of the evidence under 418. So we'll stand on our previous one.
well, and I know that wasn't a question y'all were expecting today, but it was on my mind. So anything else?
I would just add for the record, I'm not arguing about post-conviction. I'm indicating for a fair trial that this type of evidence based on their proffer is, one, there's no nexus. And again, it's highly prejudicial in terms of just getting quote unquote bad things in front of a jury, hoping that they'll just convict on that rather than listening to the evidence presented.
Okay. All right. You're excused, Mr. Little. And I think that means you're excused too, Mr. Carlson.
Thank you, Your
All
Honor.
right. Miss Ingram, you're excused as well. Position 13, Duckworth.
Present on that, Your Honor, and he is on
Yeah.
Zoom.
I am here.
Okay. Position 13, Wagner.
I am present on that, Your Honor. I spoke to him yesterday in regard to his court. He knows to be here. I did receive a voicemail from him this morning. I haven't had a chance to check it. So if we could just circle back to that.
Yeah.
Also, just this Iqbal is on this,
Mhm.
and so then she asked all her cases that tomorrow. I don't know if it's feasible or possible, but she said she'll be in on tomorrow.
Yeah, I mean, we have Zoom.
Or, yeah. So if you want me to, I can ask.
Well, let's circle back to Wagner first.
Okay.
Position 15, Fields. Some of these have trial dates, some of them don't. So I'm more likely to reset them if they don't have a trial date. But 15,
I have not seen Ms. Fields, Your Honor. I have been in communication with her though, so I don't think we could circle back to that.
Lewis.
Hudson.
All right. Bazile, position 17.
Mr. Bazile is in custody, Your Honor. I would be asking if this could be reset for one further final plea. I did receive discovery from the state at the last final plea. Just given my leave and then the fact that I was out in COVID, I haven't had adequate time to go over that discovery with Mr. Bazile. We also are still waiting on a plea offer from the state, but I'd like a chance to really actually go through the discovery with Mr. Bazile and engage in negotiations with the state to see if this is something that we can resolve.
I note on the calendar, there's a demand for speed trials.
As a constitution.
It's a constitutional demand. So,
And obviously, this is my request on the record, so.
yeah, don't worry, if it comes to that, that will be part of my analysis. So. All right. So let's reset it for 30 days, but let's get a trial associated with it as well, okay? All right, so we have DeGroot. Is he or is he on his way to Arizona yet?
He should be on his way, Judge, considering your order, and I believe, council is on Zoom, but we're working to see what is stopping that. Council may have additional information.
I do, Judge. Good morning. How are you?
Good, how are you?
I'm doing all right. We are actually talking to the jail now as well as Arizona. My paralegals calling them again to try to get an update. I believe that the order we had would have been sufficient to accomplish what we're trying to do, but nobody ever elected me sheriff. I think what they're saying is that they want an order to release him to Arizona. We essentially styled it as a bond order, if you recall, such that Arizona could come get him. I think what the jail is saying that if that bond is not posted, they won't actually release him. And it's $100,000 bond. But it sounds like if we do an order that releases him to Arizona and just style it the way that they want it to be styled, which I'm working on now, that will accomplish what we're trying to do. And we're talking to Arizona right now, trying to confirm that this order will suffice for them and they will actually come get him upon Fulton releasing him.
You know, I saw the 100,000 when I signed it and I sort of shrugged and thought, well, you know, if they're going to require it, I don't know whether Mr. DeGroot has $100,000, but we'll figure that out later. But if they're not, then fine. But I remember signing that and thinking that was a little bit odd. But and so they want an order from me releasing him
To the custody of the state of Arizona.
to Arizona.
So I've just started a little order here, proposed order I'll run by ADA Marsh that basically says order to release defendant to the custody of the state of Arizona.
Okay.
So he's not going to get released. He's not actually going to get out of custody.
Well, that was that was an incorrect characterization on my part, releasing to the state of Arizona.
Right.
But I
So-
guess if,
A little hiccup, but we finally got them on the phone, kind of confirming exactly what they'll need to allow us to do this. So some good progress here, and I would expect you'll have a modified consent order, hopefully by the end of the day, that will get this off to the races sooner rather than later.
okay. All right. Position 19, Thompson. Oh, Mr. Tucker has this one as well, huh?
And position 21 as well.
That's strange.
My understanding is that as to defendant Thompson, Xavier Thompson, there may be a pending mental evaluation. But that was, again, came in with the information about the emergency.
All right. And so you think there may be a mental health evaluation pending on him?
That's the information that came in this morning.
Well, given the fact that counsel has had his emergency, I would have reset it anyways, but he's not scheduled for trial next week. So we'll reset it for 30 days.
Oh, because I wasn't sure if Mr. Chuckle was gonna be.
All right, well, let's get him down for a trial calendar as well.
Now that doesn't conclude my.
Okay, all right. All right, well, I was presumptuous earlier. All right.
Wanted to follow through for a little.
Are you wanting to be excused too?
Not yet. I wanted to see if Your Honor might hear me on Jimmy Satterwhite, which is on the October 16th trial calendar, Judge. I and defense counsel had corresponded with Ms. Robinson yesterday about that case. Ms. Latoya Williams represents Mr. Jimmy Satterwhite in his case, which is,
I've got it up in front of me right now.
yes, Judge. That I'm referring to his 19 SC 173-443 case, Judge.
Yeah.
Ms. Williams has indicated by email and to me that she is set for trial before Judge Whitaker on Monday. It's a 5 codependent murder case. 3 of those defendants are proceeding to trial on Monday, especially set. And in light of that, she's asked the court, well, she's advised the court by email that she's in that trial. We're just trying to get some clarity from the court. If you intend, Your Honor intends, on calling Mr. Satterwhite to trial on the October 16th calendar to inquire the court if there might be a decision about that.
Yeah, no, I get you. I mean, shoot, that was my number one. Who?
Thaisa Reeves.
DeGroot? No, we don't have DeGroot. I mean, is Jacoby ready? That's the question. Okay, if Jacoby's ready. Where is Niaza Reeves on it? Oh, I'm looking at the wrong calendar.
Yes, it's supposed to be October 16th calendar.
Boy, oh, boy. Where is
She's not on that calendar for the 16th.
who?
She's nice.
I do see her in position 1. May I approach her?
Yes, please. When did we get notice from Latoya Williams on this?
Notice as to conflict.
Yeah.
Judge, I inquired of Ms. Williams about that notice of conflict, and she forwarded to me.
All right, I see.
And the file stamp date on that notice, and it wasn't filed into this 19 SC case, but the file stamp date is 9/21/2023.
I don't know. I mean, because this isn't this specially set?
The Satterwhite case, Judge?
No.
I'm unaware of anything special said.
You know what? I mean, council. Where is council today? Why is council not here? I mean, it seems pretty serious to just,
Well, Judge, this case.
what'd you say?
It's not on today, it's on tomorrow.
Oh, okay. Oh, you're right. You're right.
That is accurate, Judge. And council does have leave through today. The only reason I'm here today was because initially I was going to cover the Little case. But while I was here, I wanted to inquire with the court and
I'll send you all an email on it. I'll tell you what, Kathy, you need to look at the calendar and tell me what we're going to be having next Monday. I mean, if somebody puts an inquiry in like that, I need to know, well, what are we going to replace it with? Because we can't not have a trial next week, not with the jail issue.
I just saw that.
All right. Okay.
Thank you, Judge.
We'll get back to you with that.
thank you, Judge.
All right.
Have you excused?
Yeah, you're excused.
Thank you.
So let me know, okay, when you look at it, get in there and tell me who we're, because we're gonna have to, we gotta have a trial next week. So. And Miss Brew. Where is Miss Brew?
I believe Ms. Brew is under the 470 number.
Miss Brew? Miss Brew? Miss Brew? Yeah, call her. Well, I guess it's that number there. Miss Brew? Every question I have for you on this, I want Miss Brew to be listening. That's the problem.
I just received an email from her saying that she has issues with her speakers right now.
Is Roderick Davis here? Which position was Davis? Miss Rockwell? All right, we'll circle back to Roderick Davis, but
Yes. Hello?
we reset Roderick Davis. Yeah, I wanted to see him first. All right,
Yes.
we'll reset this case. Okay. You're good, Mr. Davis.
Okay.
All right. Nothing from Miss Brew yet, huh?
Just that email that she had an issue with the speaker. It's mainly the reason.
Well, we can ask this when Miss Brew is on, but I mean, are you representing her or not now?
I believe she wants me to represent her, Your Honor. I filed a plea in bar based on constitutional speedy trial issues, so I would ask for that to be heard at some point. But as of right now, and you can inquire as to Ms. Brew, I would need to represent her. So.
Okay. Tell her to figure out how to get on when I take my break. Because I don't want to require her to keep coming down here, but. All right. Anything else before I take a break? Okay.
gonna see what Mr. Wagner's issues are right now. That's why you need to sign.
Step right there for me.
He reached out to this Robinson. That's me. Okay, this come to. I know he said he's gonna be. Okay, I just wanted to confirm. Thank you, ma'am. All right, then, that's great.
How do you say, where's the period? So what would you run into the car? We should get out and stay cool. Okay. What do you? You pay 3,600 restitution within a year?
Yep.
Yeah, I'm pretty sure. That's good.
Yeah. 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 I do.
So what would I? Even though that is concerned. He was just. It's not even showing that.
In your package, I sent you.
Right.
I don't have a.
I'm looking at. Oh. Maybe for revocation.
I was just sitting waiting.
I just need to see a face. Well, I was worried. I was like, you always show up. Some folks I know. No, you just need your.
It's just the
full
same
goal,
one.
yeah, full goal, secure, whatever that's called. Remember the passcode?
It's a budget.
You got me on speaker. I knew she would.
I know.
Oh, I was talking to you, man. Hold on.
Which one you want to do first? Looks like it's position 9, right? Okay. On the updated one. Who's doing the plea? Bridges, I guess. Bridges is doing it.
Yes, Your Honor.
All right. Mr. Greco, you're
We're ready.
okay. This is 22 SC 185162. Anthony Brian Govia Vasquez. He's present with his attorney, Mr. John Greco, We have Mr. Roderick Bridges representing the state. Mr. Bridges, you have a plea to present?
Yes, ma'am. Thank you for your consideration. Your Honor.
Okay.
Swear the testimony that's about to be before the truth, whole truth, nothing but the truth, so help you.
Yes.
Please spell your first and last name.
Anthony Govea, Anthony Anthony Govea Govea.
All right.
Mr. Vasquez, could you, I'm sorry, Deputy already sworn in?
Yes, I did.
Okay. Ms. Vasquez, can you state your true and correct legal name?
Anthony Govea Vasquez.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far did you go in school?
21 and 12th grade.
Are you able to read, write, and understand the English language?
Yes.
You understand that you are charged with the following offenses, pleading and attempting to elude and reckless driving?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you reviewed the waiver of rights form with your attorney and signed it?
Yes.
Counselor, Judge, I think you have those forms.
I do have them.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with your counsel's representation?
Yes.
Has your attorney advised you of the maximum and minimum sentence for each charge you're pleading to?
Yes.
It's 5 years on the pleading and eluding and 12 months on the reckless driving. Do you
Yes.
understand that in pleading guilty to these charges, you are pleading guilty? I'm sorry, my apologies. Do you understand that this is a negotiated plea of guilty, which means the state will make a recommendation to the court of on count 1, reckless pleading and eluding, 2 years probation, on count 2, reckless driving, 12 months probation to serve concurrent with count 1. But the court does not have to accept the recommendation. The court can sentence you to the maximum on each charge and can run these charges consecutive or one after the other.
Yes.
So the first count 1 is 2 years probation?
Yes, Your Honor.
Okay.
2 years probation, and he also has to make restitution to the state for the damage he did to the car. And the amount of that restitution is $3,676.50.
Okay. When does he have to pay that restitution by?
I'll leave that to the court, but he needs to pay it before the, I say 1 year, Your Honor, give him 1 year to do it since he only has 2 years probation.
Judge, he's indicated he could pay it within the first year, probably do it pretty quickly. He's full-time painter with Tony's Painting.
Okay, 1 year then. All right. Go ahead, Mr. Bridges.
Mr. Vasquez, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdiction, including the federal court?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental units or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Mr. Vasquez, are you a United States citizen? Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be if you went to trial and was found guilty? For example, your guilty plea may affect your right to vote, the right to hold office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain an employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years?
Yes.
Counsel, I recall, was he using the first offender?
We would like to use first offender, yes.
Okay. Mr. Vasquez, are you asking to be treated as a first offender under the provision of the First Offender Act?
Yes, sir.
Have you either ever pleaded guilty or nolo contendere to ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, I haven't.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No, sir.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and it could be resentenced to the maximum sentence for each charge in your indictment?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defense, by entering a guilty plea on these charges?
Yes, sir.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to sentence of counsel hired by you or counsel appointed by counsel if you cannot afford an attorney at trial, the right to presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal the convicted of these charges after trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to enter a plea today?
No, sir.
Is it your decision to waive these rights to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges of fleeing and eluding and reckless driving in indictment number 22 SC 185162?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea?
Yes.
Do you understand that you have only 4 years of today for a felony to file what we call a habeas corpus challenging the constitutionality of this guilty plea?
Yes, sir.
Your Honor, if this matter had went to trial, the state would have presented evidence showing that on March the 17th, 2022, Mr. Vasquez was operating a vehicle in Fulton County on I-85 North, at which time officers attempted to stop him for speeding. He continued to flee from the officers. Eventually, the officers got him boxed in. He attempted to get out of the box in by ramming the police officer's car. The officers were able to seal him and actually arrest him at that point in time. And this occurred in Fulton County.
All right, Mr. Greco.
Judge, my client's 21 years old now. He is a full-time worker at Tony's Painting. We would just ask court to accept the recommendation, allow him to plea under First Offender Act.
I mean, the only thing I'm going to mention, I mean, when you see this stuff and type, it doesn't seem like that big of a deal, but I'm sure what you did was very dangerous at the time, Mr. Vasquez. And especially if you were on 285, you were probably riding at a high speed and causing the troopers to have to box you in. I don't know. I can see how when you're young, you do stupid things and things can spiral out of control, but I would hope you don't do anything like that again in the future.
Never.
All right, Mr. Govia Vasquez, do you understand the nature of the charges against you?
Yes, sir. Yes, Your Honor.
You just heard from ADA Bridges explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, Your Honor.
Do you understand the court is not bound by the recommendation or the plea agreement? I consent to you as I deem appropriate.
Yes, Your Honor.
Are you pleading guilty because you are in fact guilty?
Yes, Your Honor.
Ms. Greco, are you satisfied that your client's competent in understanding the plea is voluntary and there's sufficient factual basis for entering the plea?
Yes, Your Honor.
Okay. And he understands the double-edged sword of the first offender?
That's been explained to him.
What are the maximums on these charges again?
5 years for the fleet and eluding and 12 months on the reckless driving.
Okay, I mean, just so you understand, I mean, they're just general conditions, but the conditions is you're gonna have to stay out of trouble for 2 years, and you're gonna have to make restitution within 1 year, or I could come back and sentence you to the 5 years plus 12 months. Has your lawyer explained that to you?
Yes, Your Honor.
The good news is that, and you seem like a good person that just did something really stupid. The good news is you stay out of trouble and this gets wiped clean from employment purposes, and you no longer have these charges to have to contend with in the future. All right. So with that, the court finds that you understand the nature of the crimes, consequences of this plea. This is a factual basis for the plea. There is a factual basis for the plea. And the defendant has knowingly, intelligently, and voluntarily entered this plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby know the defendant that this plea may not be withdrawn in the event a defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the recommended sentence on count 1, 2 years probation, count 2, 12 months probation to be served concurrent to 1, and you are to pay restitution to the state of $3,676 within 1 year.
Yes, Your Honor.
Okay, anything else?
We got the 50 cents.
And 50 cents.
Don't forget that one.
And 50 cents. Anything else? Okay, you're excused.
Thank you, Your Honor.
You're gonna meet with this young lady real quick before you leave, okay?
All right, thank you.
Okay.
Well, yeah, there's probation. I'm not sure how he needs to pay the state, but
Mr. Britt,
Yes,
is the restitution payable to the state?
I'm gonna email you it's not, I'm sorry, but I was gonna email you
are you finished, Mr. Greco?
And the state has mailed me where to send the discovery on, provide my client with a copy. I have the restitution, so I will. provide
Okay.
that back. Thank you.
Which one are we doing next, Ms. Marsh?
Judge, I want to address the court regarding Mr. Jalen Duckworth. He's position number 15.
All right.
He's on Zoom, yes. I would like to address the court not in relation to his final plea. I think it's definitely going to be a trial at this point based on our conversations thus far. However, Mr. Duckworth is, I believe, second from the last position on next week's calendar. So this request may not even come to fruition, but I did want to bring it to the court's attention. Judge, for his case on the calendar next week, well, it's the same case. I'm asking that Your Honor remove it from that calendar and put it on another trial calendar. And this is the reason, Judge. This case has a companion or had a companion civil case. That civil case has been tried and the state has requested the transcript from that civil case. Judge, that transcript has not been provided yet. I do believe that that will be very substantial in this criminal cases, similar facts. And I believe it will be used for impeachment purposes, prior inconsistent or consistent statements. And it is very relevant and necessary for this case. So Judge, that is my request. Mr. Duckworth is out on bond. And this is the state's first time requesting a continuance in this case.
Ms. Jones?
Yes, the state indicated their position to me earlier, Your Honor. My client is out of custody, so we do not have necessarily an objection to that. I do note there was a civil case or companion case in regard to this case as well. That has been resolved.
Get Saturday was I'm trying to get out. I think we've got a fair amount on the trial next week, don't we? All right, I'll give the continuance. How
Thank you.
long do you need?
Judge, the last update that I received from the court reporter was September 21st. And she told me at that time that they are still backlogged and she expects at least 60 more days.
Okay,
I will, if it comes before then, I'll of course supplement that to counsel and update the court. But that's the estimate so far.
all right, well, we'll reset for 90 days.
Okay, thank you, Judge.
Because once you get it, you're obviously going to want to review it.
Right.
Okay,
Thank you, Judge.
all right,
Your Honor, with that, may Mr. Duckworth be excused?
yes. You're excused, Mr. Duckworth.
All right, thank you.
Yeah, she can be excused. Ms. Rockwell, you can be excused.
Thank you, Judge. Thank you so much.
Which case is this? You got it in front of me here.
Judge, this one, what's the name? Mr. Ricky Brown. Oh, I'm sorry. Did I come up to it? Please?
You go ahead and do that one.
Sure.
I'm not going anywhere.
Where's Fields? Do we have Fields? The paperwork on Fields?
Ms. Fields is here. Yeah.
Oh, I mean, Brown, which one are we doing? Brown?
Brown.
Have you got Brown on it?
Okay.
Who is this? Brown?
Go around.
Yes,
I'm
M
doing
A
Brown
R
right
S H.
Stop at any time.
You swear that the testimony that's about to give the court is the truth, whole truth, nothing but the truth, so help
Yes, sir.
you. All right, you may spell your first and last name for the court.
RICKEY. Oh, BROWN. My bad. Oh, Ricky Brown.
Are you okay with going?
All right, this is 22 SC 180816. Ricky Ivory Brown is present in the courtroom with his attorney, Mr. Philip Clark, and the state is represented by Ms. Precious Marsh. Ms. Marsh, you have a negotiated plea to present.
Yes, Your Honor.
Go ahead, Ms. Marsh.
Thank you. Mr. Brown, he's already sworn in? Okay. Mr. Brown, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Yes.
Okay. What are the names of those medications?
I'm on folic acid. I'm coherent. I just don't know the name of the medicine right now.
Okay, that's fine. That was going to be my next question. Do those medications interfere at all with your ability to understand what's going on today?
No, I'm just in a lot of pain.
Okay.
Do you want to take a seat at this point?
And I
I'm good.
just want to make sure that medication is prescribed, correct?
Yes, ma'am.
Okay. How old are you, sir?
I'm 59.
And what is the highest level of education that you have completed?
I have a associate's degree.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have been charged with one count in this indictment, violation of the state sex offender registry?
Yes, ma'am.
And do you understand that you have the right to plead guilty or not guilty to this charge?
I was in the hospital. I'm really guilty.
Okay, but I just want to make sure you understand.
Yes, ma'am.
Okay. Do you understand that if you plead not guilty or remain silent and refuse to enter a plea at all, that the state will be required to prove the charges against you at a jury trial?
Yes, ma'am.
Do you understand, have you had the opportunity to review the waiver of rights form in the indictment that lists the charge that I just explained to you with your attorney?
Yes, ma'am.
And Your Honor, I understand that you have those documents. The state moves to enter them into the record.
So moved.
So
Mr. Brown, did you understand those documents as you reviewed them with your attorney?
yes, ma'am.
And do you need any additional time to go over them with your attorney?
No, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment, including the facts and circumstances related to those charges? Or
Yeah.
that charge, excuse me.
Yes, ma'am.
Would you like any additional time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with your attorney services?
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state and the defense will jointly recommend the following sentence to the court: 5 years probation, the balance of that probation terminated upon successful completion of 50 hours of community service and compliance with the sex offender registry within 72 hours.
Yes, ma'am.
Do you understand, however, that the court does not have to accept that recommendation?
Yes, ma'am.
Do you understand that if the court does not accept that recommendation, the court has the right to sentence you up to the maximum possible punishment?
Yes, ma'am.
With that being said, do you understand that for this offense, the range of punishment is 5 to 30 years?
Yes, ma'am.
Do you understand that if the court decides to enter a sentence that differs from the negotiated plea that you were expecting today, you have the right to withdraw your guilty plea?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're placed on probation of any kind in this case, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're placed on probation, you must follow all of the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow those special conditions of probation, then you will be subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you also understand that you are not allowed to possess any firearms while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
I'm going to go over several rights with you. They're similar or the same as the ones that were contained in the waiver of rights form that you reviewed with your attorney. Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go through each of them for you. The right to a trial by jury, the right to remain of counsel, the right to the presumption of innocence, the right to not incriminate yourself, and the right to appeal if convicted of these charges at a trial. First, do you understand the rights that I've read to you?
Yes, ma'am.
And do you understand that by entering this guilty plea today, you're waiving those rights?
Yes, ma'am.
Do you need a second, sir?
No, I said yes, ma'am.
Okay. Do you understand that by entering a guilty plea today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to enter this guilty plea?
No, no, ma'am.
Is it your decision to enter this guilty plea because you
No,
are
I'm
in
sorry.
fact guilty?
Yes, ma'am.
How do you plead to the only count in indictment number 22 SC 180816, violation of the sex offender registry?
I'm guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
No.
Do you understand that you have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
And do you understand that for this offense, since it is a felony, you have 4 years from today's date to file a habeas
Right.
corpus petition, which is a petition that challenges the voluntariness of your plea?
Yes, ma'am.
Okay, thank you, sir. Your Honor, should this case have proceeded to trial, the state expects the evidence to show that in February of 1996, Mr. Brown entered a plea to an offense which required him to register as a sex offender. Upon the time of that plea, he did sign documentation and go over his understanding of his requirements to be in compliance with the state sex offender registry. Judge, however, on May 28th of 2021, near the time he was required to register for his annual registration for that year, he refused to do so, and a warrant was taken out for his arrest. Your Honor, in candor to the court, is my understanding from looking at his records, he did register for 2022 as well as 2023. It's my understanding that he is in compliance at this time. Judge, as it relates to criminal history, there's that 1996 conviction for the felony offense, which required him to register as a sex offender. Then I also see a October 8th, 2010 registry violation that was here in Fulton County. He does not have any felony convictions since 2010.
Yeah, Mr. Clerk.
Yes, Your Honor. We're asking the court to accept the deal. just be as quick as possible. Mr. Brown is obviously in a great deal of discomfort. What I've offered to the state and what Mr. Brown has informed me is that he's undergoing some significant medical issues right now. He has had some cancer that has had a relapse and that he's on medication for that. He wants to go forward today. He's expressed that to me numerous times, but I do believe he's in a bit of discomfort. Other than what the state said, this appears to be an isolated incident. What Mr. Brown informs me is he was in the hospital on his birthday back in 2021, that once he was released, he had a head injury at that time. Once he was released, he missed his report date and didn't report back to them. He's been in compliance since he was arrested and bonded out on this back in 2021. So I don't think this is going to be an issue going forward. He's going to be ready to complete his community service and have the probation terminated as soon as possible.
Okay. Mr. Brown, do you understand the nature of the charge against you?
Yes, sir.
You've just heard from ADA Marsh explain all the rights you give up binding this guilty pleas. Your ways to give up these rights and have this court accept your plea of guilty.
Yes, sir.
Do you understand the court is not bound by the recommendation of the plea agreement? I can sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Clark, you satisfy that your client is competent and understand the plea is voluntary and there is sufficient factual basis for ending the plea?
I am.
All right, I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence as follows, which is 5 years probation, balance to be terminated upon completion of 50 hours of community service, and he is to be in compliance with the state sex offender registry within 72 hours.
Thank you, Your Honor.
Okay, is that it?
Go and then come
Yes, Your
back.
Honor.
You're excused.
Yeah, that concludes my business. Now, excuse me.
Yes, you're excused, Ms. Marsh.
Thank you.
Are we doing fields now?
Yes, Your Honor.
Okay. Twenty, 15.
JYFIELDS. Joy Fields.
Ms. Fields, are you at this time taking or under the influence of, I'm sorry, Your Honor.
Let me just for the record.
I
rule.
apologize.
That's all right. That's right. This is 22 SC 181486. Ms. Joy Nicole Fields is present in the courtroom with her attorney, Mr. Philip Clark, and we have Mr. Roderick Bridges representing the state. Go ahead, Mr. Bridges.
Ms. Fields, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there a medication that you normally take that you have not been given today?
no.
How old are you and how far have you gone in school?
37 in some college.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that you are charged with the following offense of aggravated assault, which carries a sentence up to 1 to 20 years?
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you reviewed the waiver of right form with your attorney and signed it?
yes,
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
yes,
Do you need more time to discuss the case with your attorney?
no,
Are you satisfied with your attorney's representation?
yes,
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any respect to name?
We do.
Ms. Field, have you been arrested on these charges?
yes,
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We did not.
Has your attorney advised, I'm sorry, I did that already. Ms. Field, do you understand that this is a negotiated plea of guilty, which means that the state will make a recommendation to the court as to sentence to the reduced charge or aggravated simple assault with the simple assault with the sentence recommendation of 12 months probation, anger management, no violent contact with the victim in this case, and that's it. And I'm sorry, stay gainfully employed or stay gainfully employed.
Yes.
But do you don't understand the court does not have to accept that recommendation? The court can sentence you to the maximum of each charge and can run those sentences consecutively or one after the other.
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental units or special conditions of probation without being subject to revocation of the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you plead guilty to a crime against, I'm sorry, wrong thing. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Ms. Fields, as I understand it, you're asking the court to treat you as a first offender under the provisions of the First Offender Act.
Yes.
Have you ever pled guilty or no or ever been convicted of a felony in the state of Georgia or other jurisdiction?
No.
Have you ever been sentenced of any crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked? You could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment.
Yes.
Do you understand you waive any and all defenses, including any mental health defense, by entering a plea of guilty today?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at trial of your case, the right to presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal the convicted of these charges after trial.
Yes.
Has anyone forced or promised you anything to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
And she would like to plea under offer.
So offered and forced offender?
Yes.
Okay.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, that this plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes.
How do you plead to the charge of simple assault in indictment number 22 SC 181486?
Guilty by Alfred.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea?
Yes.
For a misdemeanor, you have 12 months from today's date to file what we call a habeas corpus challenging the constitutionality of this guilty plea.
Yes.
Your Honor, if this matter had gone to trial, the state would have shown that on May the 29th, 2021, at the address of 5101 Old National Highway, Atlanta, 30349, Fulton County, Ms. Field called the police regarding individuals attempting to jump her. When they arrived and actually investigated the matter, they determined that Ms. Field was engaged in a physical altercation with a Tori Adolphe, and it's Adolphe. At that point in time, it was alleged that Ms. Fields had a knife. Based on the information and discussion with the victim in this case, who was also charged with simple assault, she said that Ms. Fields never had a knife. Based on that, the purpose of the reduction in the sentence, Your Honor.
Okay. Mr. Clark.
Yeah, we're asking the court to accept this. This is I guess what we would offer to the court is this is a compromise deal. I do think that there is obviously based on what the state has proffered even just now, there is going to be some major issues in their case going forward to trial. Ms. Fields is 37 years old. This is, to my information, the only time she's ever been arrested. She has sole custody of 3 kids, works at Ted's Montana Grill downtown. Outside of that, helps to take care of her grandmother who is in hospice. So this is a completely isolated incident. We don't believe this occurred at an apartment complex she was living in back in, I believe, 2019. She no longer lives there. I don't think there's going to be any issue with her going forward on probation. And we're asking the court to accept this and treat her as a first offender.
Okay, Ms. Fields, you understand the nature of the charges against you?
Yes, sir.
You just heard ADA Bridges explain all the rights you give up during this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement? I can sentence you as I deem appropriate.
Sir.
Although you are not admitting guilt, you decided it is in your best interest to plead guilty because at trial, the evidence presented against you may be strong. Do you freely and voluntarily enter your plea of guilty to the charges against you?
Yes, sir.
Mr. Clark, are you satisfied your client is competent and understand the plea is voluntary and that there is sufficient factual basis for entering the plea?
I am.
I find there is sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I'll accept your guilty plea and sentence you to the recommended sentence, which is to reduce the one charge of simple assault and give 12 months probation and required to take a anger management course, no violent contact with the victim, and stay gainfully employed.
And
oh, you know what? You first offender.
And I apologize as well, Your Honor. I had wanted to request that Your Honor file an order sealing this from a record at the time of the plea. My understanding was the state didn't have an objection, but this has impacted her ability to get employment while this has been pending. She obviously does have a job, but I think more avenues would open up to her if this was not on a record.
Mr. Bridges, do you have any objection to that?
Objection, just need for him to put the statute on the record because I told him I couldn't remember.
I'll provide a written order and I
Okay.
can CC you on that.
All right, and let me revise, I said that I'd found the sufficient factual basis, but I did not include first offender. So the court finds that you, Ms. Fields, understand the nature of the crimes, the consequences of this plea. There is a factual basis for the plea. The defendant has knowingly, intelligently, and voluntarily entered this plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant this plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which I agree to it to reduce it to simple assault, 12 months probation, anger management, no violent contact with the victim, and to stay gainfully employed. And Mr. Clark submitted me that order to seal it, and I'll sign it.
Thank you, Your Honor. Hang out for just a second.
All right.
Misdemeanor probation just needs to speak with you.
All right. Thank you.
Okay, you're welcome. Do we have another one yet? Or is that? All right, well, let's, Mr. Clark, you ready for Ms. Brew?
Yes, Your Honor.
All right, Ms. Brew. Ms. Brew. All right. Where's the add-on here? All right, let the record reflect that we tried to get through to Ms. Brew is appearing by Zoom. We tried a couple hours ago. She was unable to speak. She is unable to speak again to discuss the plea and bar constitutional speedy that she has filed. Did you take that down, Ms. Meyer? She is not speaking though. And any sort of technical issues she has are Ms. Brew's issue. It's the Zoom is provided as a convenience to I allow the Zoom as convenient to the defendant, but as I said before, let the record reflect that we've now tried a couple times over the last few hours and Ms. Brew has been unable to respond to discuss her case and specifically the constitutional. Let me look it up here. The constitutional, well, that's what you had filed. Let me, the plea and bar and demand for acquittal, she's unable to speak to that, or she's unable to be present while her attorney speaks to it. Anything else, Mr. Clark?
I mean, I would state I'm not, I guess I would, I'm not withdrawing the motion. Obviously, she's not presenting herself on Zoom. I guess I'd ask if we could address it if she's here on Monday morning for trial. The only other thing I'd note is I've communicated the state filed or made an updated offer to us. I've communicated that to Ms. Brew. She indicated that she's rejecting that. I'd be prepared, I believe, on Monday. The only wrinkle with that is I do have the case in the consolidated calendar that also appears as it may be going to trial. So I can file a notice of conflict, but that Smith case would take precedence as it's in custody and actually older than this one. So
Well, you've got a couple potential cases, and once we get through today, we'll work through those. I mean, I see Miss Brew on there, but I mean, I'm not I will say this, Mr. Bridges, what's the key piece of evidence that you have in this?
It's all on video, Your Honor.
So these are body cam videos?
All of the camera, from her striking the officer to them attempting to carry her out of the hotel, her resisting, and her also kicking the second officer, Hernandez. And I apologize, Your Honor. I thought Ms. She was gonna be here today. I was gonna have an opportunity to show her the videos. I don't know if council's had an opportunity to show the video, but I want to show the videos and make sure she understands that there is no doubt that she is in the video and she's the one acting in the videos.
I'm not gonna address any, it's obviously not.
Well, I'm not asking to try the case here, but what I just want to make sure that Ms. Brew is aware of the that there is evidence in her case.
I've received discovery when I first got on this case. It's been shared with Ms. Brew. I mean, as far as our personal communications, I can say that I've shared that discovery with Ms. Brew. That's all I'll say on that.
And fair enough. Like I said, I'm not asking you to try it, but I'm wanting to make sure that Ms. Brew is aware of the fact. You know, I'm torn with Ms. Brew right now because Ms. Brew is out of state, and I know that Ms. Brew, it's a difficulty for her to come down. But and so I would normally just reset this more as a convenience to her, but then, you know, it seems like there's going to be complaints and all sorts of speedy trials scheduled. So there's a side of me that thinks, well, do I just have her waiting there like she should be on the calendar, ready to go? If, you know, you've got some conflicted cases, but we're never 100% sure where they're going. So give me a day to think about this. And as I said before, Ms. Brew appears to be unavailable for her for this final plea calendar. So Ms. Brew's, you're saying that she's rejecting the plea, but I would have liked to have gone over that with her present one more time. And with that, we will keep her on the calendar for now, but I reserve the right to reset it over the next 24 hours. All right. What else do we have? I see Miss McCauley sitting there. What do you have? Oh, Mr.
Position. A little early in the
calendar. I have Mr. Lewis on the calendar. It's a speedy trial. I think it's also scheduled for trial on Monday, and Mr. Hudson is his counsel.
Oh, that's
Hey,
right.
Judge.
Hello there, Mr.
Ms.
Hudson.
Robinson, thank y'all for working with me. Judge,
On
I had
position
already-
18, Judge.
I had already let Ms. Robinson know I was gonna be late. Judge, is Mr. Lewis here? He's here. I would like to have him brought up.
Okay, yeah, let's bring out Mr. Lewis then. Let me pull out my notes on Mr. Lewis.
Judge, you remember last call, I said, what I said about Ms. McCauley? We finally about to get, no, I'm just letting you know, that we finally about to get smooth on this case.
Well, I mean, it's due for trial on Monday, so.
No, we ready.
You need this?
Yeah, I need this.
Okay,
Just if
no
you don't
worries.
mind.
You're fine.
I'm gonna get it in a minute.
I'm just gonna move our stuff out of the way.
And y'all, I believe we're gonna have to go on the record. That's why I wanted Mr. Lewis present.
Yeah,
Okay.
Not offended.
I got it.
Okay.
I'm just making sure that it's. plays that
Okay.
on there. Fine. You don't have any issues and you have your laptop with you?
I don't.
Okay, I can show you how to play it after we're done with the policy calendar.
Now you've got a pending 414 notice, right?
He does, Judge, and I'm happy to address that this morning. I'm prepared to do that.
That's the motion.
No, that's motion limited is what I found last night, and so I wanted to reserve.
That's
some time. Today or maybe back Friday or prior to trial, like whatever the court wants to do. But I did file that so much.
She did, and I don't have a problem with it.
Okay, I just have it for you, and just, if you want, I can show you before you leave. how
Yeah,
to
please
play it.
show me.
Yeah, absolutely.
I got Julie.
That's the,
Well, Julian's gonna be saying.
Yes.
that's the, the other acts, the child,
Right.
which I don't know why, but I'm becoming somewhat of an expert on those motions.
Julie, we sent signature for this right.
Okay.
That's all.
That's fine. That's fine.
Miss who? Oh. Well, we can discuss that with Ms. Sharp at a very 10,000 foot. We can have a very 10,000 foot discussion with Ms. Sharp about her case now that Ms. Rockwell is not there. Well, that's what we need to discuss. I guess Kathy, can you see if you can get a hold of Miss Rockwell? Tell her that Quanta Sharp is on the Zoom now.
I'm texting him too, Judge.
Pardon me?
I'm texting him as well.
Renee, all right.
No. Yeah, I want him to sit down. Thank you, appreciate it.
All right, what position is this again? Okay. What position did you say?
I think it's position 18. It might be 16 on your.
All right, ours, they vary. Okay, so this is position 1622 SC 185-387, Markel Lewis, who's present in the courtroom with his attorney, Mr. Jacoby Hudson. And we have Mr. Jordan and Macaulay representing the state here. Okay, go ahead, Mr. Hudson.
Your Honor, we're gonna announce ready for trial. Your Honor, as you know, this case been around. I filed a speedy back in 2022, December, but I knew it was a stay and been through a couple of DAs. But like I said, when Ms. McCauley got on it, she immediately sent me the discovery. She sent me everything. She just gave me some supplemental discovery today, but it shouldn't affect anything. I already got it. It just, she put it on the disk, flash drive. We're announcing ready, Judge. Also, I had spoke with Ms. Robinson. I was just gonna make an open request and I'm gonna get you the paperwork like right now. Judge, we're gonna ask for Mr. Lewis to be for a grooming order for trial. I'm going to put that together so that way he can get his face shaved or anything. Identity is not really an issue in this case. I mean, it is, but like not like he got any facial tattoos. I just want him to look presentable for the jury. Also, Your Honor, I have his clothing. His mother, Ms. Lewis is present and his father's present as well. So I have his clothing. We'll be prepared on Monday and we're announcing ready. Subject to the state's Ms. McCauley's motions.
Good morning, Judge. The state is ready to proceed to trial on Monday. The state does acknowledge the speedy trial demand and the state is ready to try the case. There is a pending 414 that's before the court. I also filed a motion in limine. I'm prepared to argue that today. We can also argue it closer right before jury selection, after jury selection, whatever the court's pleasure is. The state will have additional motions in limine, but they're not really, one is not right based on the time frame of where we are with the trial date being on Monday, and then the others are just standard filings in these cases.
So your motion in limine is an omnibus one?
No, the motion in limine I filed yesterday is actually very specific. But the additional motions in limine, which I would have, would be to accommodate the child witnesses in the courtroom.
Okay, I
which
see
is,
that
you
motion
know,
in limine.
Pursuant to a statute, we would invoke the protections under Rule 412, which is pretty straightforward and standard. And then we would just have a motion, an oral motion in limine regarding any speaking objections and bench conference.
Judge, I told you Ms. McCauley was gonna be on point, so I'm fine with it. Judge, the only thing I ask is that on the motion in limine, that we do this on Monday. Ms. McCauley, I don't like to refer to pronouns, Ms. McCauley filed motions, and I would want to continue to review their motions and get the applicable law that I feel will support Mr. Lewis's position in this case, because a big part of their motion in limine deals with our defense. So I would like to continue to research the law, and on Monday, we'll be prepared to argue those motions in limine, and then we can go right into jury selection.
You said the motions in limine. I mean, there's the character evidence one is what you're talking about.
Yes, Judge, and it's a compound motion, so it deals with improper character evidence related to the related to some of the witnesses. It relates to improper character evidence of the victim children, and then it also includes a provision to prohibit eliciting testimony of a reverse propensity defense.
That's right, Judge.
And the 414, would you be prepared to argue that later
I'm prepared to
today?
argue the 414 today.
Mr. Hudson?
I'm not.
Well, I mean, it's been,
I'm not. I got other court appearances, Judge, and I got a conference with his family, and so I would prefer to do all the motions. I believe all these motions will take between 30 minutes to an hour.
I believe the motions in limine would take about 30 minutes to an hour, which is the normal time frame for any motions in limine pre-trial for most cases. The state's fine with delaying the 414. Be fine to proffer that evidence so that's in the defendant's presence and put the offer on the record today prior to Mr. Hudson having an opportunity to speak with his client, just so we're all clear of where we are.
you're talking about your offer.
The state's offer and the evidence and what the state would show a trial. The state anticipates the evidence will show a trial.
Okay. If you want to put that on the record, Ms. McCauley, that's fine. We can do it right now.
So they would do that, Your Honor. in
Yes.
special use cases.
Yes.
How long do you expect the trial to take?
State has about 17 witnesses. I think that we will get pretty quickly. I would say we would be at closing arguments Thursday.
Wow. Judge, we got 2 witnesses, and my client will not be testifying.
I say 17 because there's a lot of very small witnesses. And obviously, when we get time for trial, there may be some that are not as relevant as others. When we skip over them, like right now I'm counting Dr. Little, but I have the forensic nurse examiner under subpoena, so I may not use Dr.
All right.
Little. It's trial in a week, Judge.
It is
I'm not
trouble
really
in a week,
concerned.
Judge.
The one thing, and I know the state has had, we have tried a lot of cases this year, Judge, and child sexual abuse cases in particular are particularly challenging to pick a jury on. So that would be where I think we're going to have any delays would be during jury selection. So I would reserve Monday. We need to start in the morning as soon as possible with jury selection, just because we can't start like 1 or 2 o'clock in the afternoon, so we won't get through all the panels.
Well, we've got the motions in limine in the morning, so.
I can be here, Judge, at 8:30. I don't mind. I can come here Friday and do the motions in limine as well, prior to trial, whatever. the court's
Friday, I'm
pleasure is.
unavailable, Judge, so I would prefer Monday as well.
Judge, I don't.
Let's do Monday.
And we can come at 8 o'clock or 8:30.
Yeah, I can be here. either.
Let's be prepared to come in at 8:30 then on Monday.
Okay.
What? Well, find out from the other case managers, because I keep hearing defendants are coming earlier than 9.
If you make a special request, they can transport them early.
Do you hear that? Because this is important. I mean,
60 jurors.
Judge,
Let them send 48. We need 60.
Judge, we need.
well, that was gonna be my next question.
We need 60 jurors, Judge. Don't let them send 48. She's absolutely right. I was gonna say that too, because we're gonna probably have a lot of strikes and, for cause and
Yes.
challenges.
Need 60 jurors. $8:30. Tell them it's a special request. All right, why don't you go ahead and present the evidence in the plea offer?
Sure. So
What, Mr. Hudson?
Judge, could we do this on Monday due to the nature of the charges?
can I just put the offer? I'll do it by count.
Okay, yeah, let's do that. Let's do that. Thank you.
And that's fine. That's fine.
Thank
Judge, the defendant is charged with 2 counts.
Right.
Count that both of them carry the same sentencing range if upon conviction. Upon conviction, count 1, the range is 25 years to life. Count 2 is also 25 years to life. They do not merge. They do not vacate because they're different victims in each count. The state's offer prior to trial is 12 years to serve with life on probation. Conditions of probation would include all of the special conditions of probation as required by the SOR. And no contact with either one of the minors named in the indictment or their family. Also, I will put on the record that there are outstanding charges related to this case in another county. So this case will also include a prosecution in another county. I have not spoken with that district attorney's office to speak with them about a global. However, I will speak with Mr. Hudson if that is something that he is interested in and make that phone call. No guarantee that they will agree to that.
Mr. Hudson?
Nothing further to add, Your Honor. The offer's on the table.
It expires on Friday.
It expires on Friday. They give us opportunity to talk to judge in case this doesn't fold. But right now, we're gonna maintain our position of not guilty. And I've been in touch with Ms. McCauley, and we'll be prepared to argue the motions in limine as well as the other pretrial motions on Monday if we don't come to a resolution.
The only thing I want your client to understand, and there's no bluffing in here. The way that my calendar is shaping up right now, and we're going to sit down and go over it and give the attorneys a better idea what the order is, what's in it. But I would say there is a good chance that this case will be going on Monday.
Judge, I would actually request for this case to be first out on Monday because I have 2 minor victims that have to miss school and I have multiple professional witnesses and experts coming.
Okay.
So I would request to be number 1.
And Your Honor, no filibustering. That's why I filed a speedy.
All right, Ms. McCauley, give me a couple hours a day to go through all that. We will take that into account when we reorganize it, but you know, the only hesitancy I have to Ms. McCauley's request is if there's another one on this calendar that has the same request or whatnot, but if I go through it and there's no issues with any other cases, this will be the number one case out.
I'm prepared for that, Judge. That's why I filed a speedy. And like I said, I stated before, Judge, that's why I gave the state an opportunity. I want the truth to come out as well. That's the reason why I've let them go through multiple DAs. And once I saw that Ms. McCauley was on it, I felt confident that we will be prepared to move forward. So we'll be prepared for Monday.
And your client, it goes without saying, I'm sure you've explained to him that if he goes to trial and if the jury convicts your client on both of the counts, that he could be facing 2 life sentences.
That's correct, Your Honor. That's why I'm about to speak with my client as well.
Okay.
All right, and like I also stated, Judge, I've been provided everything. Ms. McCauley gave me the offer ahead of time. I spoke with my client. By Monday, we'll know what we're doing. All right?
Okay.
All right, thank you, Judge. Can I go in the back? Speak
Yeah.
with you tomorrow?
You're excused.
All right. Oh, Judge, also about the grooming order, you'll sign off on it?
Yeah, you send me that and I've not done a grooming order yet, but it sounds like something that's pretty straightforward. So, okay. Okay, what position was this again? I don't see sharp. Number 4. Okay, so Ms. Rockwell, you're online. Can you hear me?
Good morning, Judge. Good morning,
And
Judge.
I see Ms. Sharp is on as well. Can you unmute Ms. Sharp? So this is 22 SC 182340. Both are on Zoom, Ms. Quanta Sharp and Ms. Renee Rockwell. What was the issue? Was this the limited appearance that you filed, Ms. Rockwell?
Yes, Judge, there's been a limited appearance, and I think that Ms. Sharp needs to update her address. Thankfully, Jet Bonding Company, thanks to your staff, Judge, Ms. Robinson, Jet Bonding Company was able to locate her, and so she's present today. But I did want to notify her that I am filing a motion to withdraw from the case. And I do need a good address. If she could just put a good address in the chat so that we can update her address with the court, and also so she won't miss court anymore. And I'll be able to send my
she's welcome
paperwork
to give
her.
you her address, Ms. Rockwell, but she needs to update her address with the clerk. That's where all of the where it goes. And so, Ms. Sharp, can you hear me?
Yes, sir, I can hear you.
All right. So I had them try to find you because I don't see any reason to unnecessarily put somebody in jail for failing to appear, which is what we would have done had your bonding company not found you. So it's very important that you keep your address, you stay updated with the clerk's office. Okay.
Yes, sir.
And I also want to make sure you know that Ms. Rockwell entered a limited appearance for you, and she has stated that she's planning to withdraw. So you're going to have to find another attorney.
Yes,
you've got, you've got an aggravated assault charge against you, which is a serious charge. Do you have plans to find a private attorney? Are you going to try to, I don't know whether you qualify for a PD or.
I am going to hire an attorney. I'm going to see one tomorrow. So I will have that worked out by the end of the week.
Okay, because the attorney can also help keep you updated as far as when your court appearances are going to happen. So I want to make sure that when we call you again for another court appearance, this was a final plea, that you're aware of it, that you're present, that your attorney's present, and we're able to move forward with your case. Do you understand that?
Yes, sir, I understand.
Okay, so you're gonna get with the clerk's office and update your address, and then also have your new attorney file an entry of appearance in this case.
Yes, sir.
Okay, anything else, Ms. Rockwell?
And Judge, yes, Judge, if Ms. Sharp knows how to use the chat function, I'm gonna put her indictment number in the chat function just so she can give that to her new attorney, and the attorney could call me also for any kind of details.
Do you know how to use the chat
I'll put all my
function
information.
on Zoom?
Yes, I see that it's a chat down at the bottom. So I see right here where it's like a
Okay.
message.
Okay, because we want to, we don't want to necessarily have a bench warrant out for you and have you put in jail, but it's your duty to make sure that everything's updated, okay?
Yes, sir. I understand. And thank you guys so much for contacting the
Okay.
fund to contact
Okay,
me.
perfect.
Okay, all right.
Perfect. And just after I chat with her, may I be excused and may she be
Yes, after y'all are
excused?
done chatting, literally on the chat, you're both excused.
Okay, thank you
Judge,
so
would you
much.
just reset? Could you
Pardon
just
me?
reset her, please? Could you reset her to another final plea, Judge, please?
Yeah, we're gonna reset her to another final
Okay.
plea. Everything's okay.
Thank you so much. Thank you, Judge.
All right.
All right. Thank you.
All right, bye-bye.
Bye-bye.
Okay, yeah, so Mr. Shepherd,
Mr. Shepherd Tinger.
I see Mr. Tucker keeps coming on. Mr. Tucker?
Yes, sir.
We were made aware of your emergency. Is there anything you need to add or?
No, sir. I was just told that I needed to get on the Zoom, and I did what I was being told. And if there's not necessary for me to be there, I'll head to my next court.
No, I can't think of anything for Mr. Tucker. Can you?
And I apologize about this morning. I've just been dealing with some personal stuff that just
No,
keeps
I'm
taking.
well aware of that, Mr. Tucker, and you're in our prayers. So,
Thank you so much. That's what we need now is prayers.
okay. All right.
So
You're
I
excused.
appreciate it. All right. Thank you. You have a wonderful day.
All right. Bye. All right. Now, where's Shepherd Tigner?
Looks like he turned on his mic.
He
Mr.
is
Shep-
right here.
All right. Okay. I see Mr. Shepherd. So this is 22 SC 185181. Aaron Shepherd Tigner, who's present on Zoom, and Miss Tanya Jones, who's present in the courtroom. Let the record reflect that Mr. Shepherd Tigner is in the hospital by Zoom, and he has some sort of breathing apparatus over his face. So I think he's having a little bit of difficulty communicating. But who has this with the state?
This would be Ms. Iqbal, Your Honor. And I would also like to point out that Mr. Rogers has another case pending that didn't make this docket that we would like to keep together.
I mean, Mr. Shepherd Tigner.
Oh, never mind. I was
That's
thinking
all
of
right.
somebody else. Yes. So Mr. Tigner is in the hospital currently. He's has some breathing issues. This is Ms. Iqbal's case, Your Honor. I do not have an offer and haven't been able to speak with Ms. Iqbal regarding an offer. I know she noted that she might want to try to do these tomorrow, but because Mr. Shepherd Tigner is in the hospital, I can't imagine we're going to resolve this.
So was in the hospital over the weekend. She will be back tomorrow, but she will be trying case in Judge Adams' court. But we can get someone to stand in for her.
That's right, because we were supposed to, I was supposed to have Iqbal on Monday. But somehow, I don't know whether with her low case count, somehow she found a case that was older than mine. And I remember the case. I know it better than a number of mine.
Yeah.
So,
But,
so she's gonna be here on Monday?
So I don't know if she'll be here on Monday. I know that she'll be here Thursday, or she's supposed to be here tomorrow to finish trying her case that Asia Besa and Adam have been trying for her. I think that she may be here on Monday. I don't know if she'll be ready to be candid with the court.
It's more out of curiosity.
Yeah.
Let me just see something real quick. All right, so this, Mr. Shepherd Tigner doesn't even have a trial scheduled, so we'll reset this. Let's, how much time do you think we should reset this for, Ms. Jones?
I'm comfortable putting it on the November docket.
All right, let's reset it for the November docket. Okay, Mr. Shepherd Tigner, you are excused, and I hope that you get to feeling better, okay? All right, okay. November docket. Is there anything else we need to do?
Yes. Those are mine, Your Honor. Position 1, Corrine Rogers. That is the one who has another case pending, Your Honor, that didn't hit this docket, which is going to be 23 SC 185264. He is present in the courtroom, Your Honor. This is another one of Ms. Iqbal's cases. I do not have an offer on either of these cases, Your Honor.
And I assume you'd like to have a global offer when you do get one.
I would, at least to talk to my client about.
All right, well, the prosecutor's not here. It's not scheduled for trial. So I'll, just continue it to November?
That's fine, Your Honor. No objection here. Okay.
Okay.
Yep, no
Well,
objection to that, Your Honor. So 10/25 is your next court date, okay?
October 25. Okay. Okay, you're excused.
Your Honor, I also have position number 2, Ms. Kimberly Pleas. This is also Ms. Iqbal's case, Your Honor. I have had discussions with Ms. Iqbal in regard to potentially coming up with a pretrial intervention plan for Ms. Pleas. These charges arose out of some medication issues. She has some mental health issues, and there was some issues with her medication. And I haven't had a chance to follow up with Ms. Iqbal. I did send her an email, but I understand she's been under the weather, Your Honor. So we would just request a reset so we can work out the term of that PTI. Okay, I can do that too. And certainly if we're able to get those terms, we can just email you the order.
Okay. All right.
And maybe let's do a 2-for-1. Okay. Sounds good. I also have position 16. Mr. Wagner is present.
Morning.
He was in calendar to the court a little late this morning. He indicated to me he had car trouble, but he is here presently. This is another one of Ms. Iqbal's cases. Your Honor, my understanding is we are moving forward to trial at this point. So we would just request he be placed on the next available trial calendar. And if Ms. Iqbal and I can work it out in the meantime, we will. But otherwise, I know Mr. Wagner is very anxious to resolve this matter.
All right. Okay. We will put that on the next available trial calendar. You're excused, Mr. Wagner. No, we're gonna have to find the court date.
Yeah, just reach out to me. Miss, please, you're excused.
Thank you. Have a great day. All right.
Do I have a trial date on the 16th?
What position? Who are you again?
Miss, please.
Oh, please. Yeah.
That will not be for trial, Your Honor, as indicated. This is a family matter that I think we can work out with a PTI.
Thank you.
Yeah, I mean, Miss Police, you weren't scheduled for trial to begin with. So, oh no, you were for the 16th. That's right. This is an Iqbal case?
It is, and we've had previous discussions about sending this to PTI.
All right, we'll take it off the trial calendar. Your attorney seems optimistic it'll be resolved. So,
Thank you, Your Honor.
all right, you're excused.
And last but not least, we have Mr. Alex Simpson. He's on Zoom. Sorry, I'm cutting you off.
Yes.
There we go. And I think his mom is on too, because I was communicating with both of them this morning, because he did not appear this morning. But that was just a little bit of a mix-up. I sent him the terms of his virtual PTI, and he assumed that that was just a done deal and didn't need to come today.
Sorry about that.
That's okay, Mr. Simpson. We have worked out a pretrial intervention, a virtual program for Mr. Simpson to complete. I sent the draft to the ADA in this particular case, so I assume that we'll get that order to you today or probably tomorrow.
Okay. All right. Thank you, Mr. Simpson. Sorry, still carries some weight in this courtroom. So, you know, as
Thank you.
opposed to just
And I know it's
peering
ADA.
into a black hole forever. So.
No, yeah. No, I'm okay. Thank you, guys.
All right. Is there anything else on Simpson?
No,
All right. You're excused, Mr. Simpson.
Okay, you guys have a great day. Thank you, Your Honor.
All right, Mr. Clark. Let's
I
do-
have Mr. Favors. I'm not sure. My calendar was a little off on the numbers.
Yeah, I'm up favors. You'd said you wanted to pre-try that.
Yeah, and I discussed it with Mr. Bridges. I hadn't had discovery, but Mr. Bridges did get that to me while we were in court today, as well as an offer. However, Mr. Favors is in custody on a new set of charges that are more serious than these. So Mr. Bridges may indicated that offer may change. I think regardless, just based on the fact that he's got these very recent cases coming out, I'd ask if this could be reset one more time. Give me a chance to look at discovery and talk with the state some more. Here in Fulton, yeah, and I can.
Yeah, she has 2 new cases.
Probably in CP level, yeah.
They're CPs. Yeah, they're CPs.
Yeah.
Wait a minute, is he in jail or not?
He is.
Okay, all right.
He was arrested within the last week and a half or two.
All right. You will reset it for 30 days. Is that, yeah?
I would say set it up further than that because he's got 2 cases. And one of them is a traffic case. That's probably- So,
All right, we'll reset it for 90 days then. Is that all right?
I don't have any problem with that. He's
All right. Is that it? I think so. I've got a little, Xavier Thompson, that was Iqbal anyway, and that might be a mental health. Yeah, I think that's it. All right, we've got a little work to do back in the office and we'll let you know. Well, man, I've been a little busy up here. So Iqbal's been in the hospital with COVID? Boy, what the knives are coming out.
I heard Mr. Hunt's asking.
No, because it's got my name next to it.
Oh, I'm sorry.
Yes.
I'm actually going to be meeting with Judge Adams in a couple days on